SJC-11228, Commonwealth versus Bullets.
Yes, sir.
Good morning. May it please the Court. Andrew Crouch on behalf of Michael Dreslinski, who appeals from convictions out of the Worcester Superior Court. With the time I have today, I'd like to actually begin with a different issue, the De Giambattista issue and the instruction given in this particular case. As the Court is aware, from its decision in De Giambattista, there are circumstances under which there is the preference that police record custodial interrogations, and where that does not happen, there is now a standard instruction that is supposed to be given to the jury to help them contextualize that. And that is based upon, this Court's, wide-ranging statements in that decision talking about the inherently unreliable and the woefully incomplete nature of repeating back an interrogation.
The instruction was given. You object to the additional
Correct.
instruction,
Yes.
which relates to the fact that there was evidence, which we have said in other opinions, can be put in as to why
Yes.
there was no recording.
Yes, and actually...
And so it's your position that the evidence can go in, but the judge cannot give any kind of instruction to the jury to guide them as to that. That should be basically left without any mention by the judge in the instruction.
I would say that there are two problems here with the instruction. One is that De Giambattista, as Your Honor notes, does indeed provide for the circumstances under this case. It was well aware that these kind of circumstances would arise where a defendant would refuse the recording, and therefore it said in the language of De Giambattista that that individual would be, that the Commonwealth is certainly within its rights to argue the particular circumstances leading to the refusal, which it does here at length.
Argue, but I mean, it presents evidence as to that.
Yes, it presents evidence both in terms of an oral recording and a written waiver form signed by Mr. Dreslinski. It argues that then Trooper Pavero testifies as to that, and Trooper Pavero testifies as to a lot of the details of that conversation. So I think the first primary part is that the De Giambattista court, that decision, takes into account that this is going to happen and says, regardless of the circumstances under which the recording is not made, this is the instruction that is to be given.
Right, but it doesn't say that. I mean, the instruction here was one of the factors you can consider is whether the person, the defendant, isn't that right? Did or didn't, or didn't allow, or did or didn't allow?
Well, the instruction...
Did or didn't request?
So in response to Justice Lank's question, my second problem with this is the actual language of this particular instruction. So the judge goes beyond what was provided for in De Giambattista. That's the first part. But here, the judge actually does eventually essentially weighs in on the evidence and says, consider the evidence that the defendant was given the opportunity to have his interrogation recorded and waive that right both orally and in writing. And I would suggest that the judge is actually getting into the evidence. Now, there is certainly sufficient evidence on the record to support that as a finding, a factual finding within the province of the jury. But here, the judge is actually, I think, putting sort of a hand on this issue, getting into what the jury is supposed to be determining by giving this particular instruction. Should this instruction be given? I suggest that De Giambattista, makes clear that there are circumstances under which the Commonwealth can make the arguments that it did in this case, and it does it extensively through, both trial evidence and in its closing argument, in pages 59 and 262 of Volume 8. And it goes on and makes very strenuous arguments about the defendant and the contextualizing the refusal here. I think that that's sufficient. I don't think that the judge needs to weigh in anymore, because the whole purpose of De Giambattista, as this Court has noted, is to talk about the problem that still exists even in cases where a defendant refuses. And that is namely that the record is woefully incomplete and inherently unreliable in terms of what happened in that conversation. Here, Trooper Pavero testifies that the defendant, Mr. Dreslinski, changes his story on a couple of different occasions, at least 4 different. We don't know if it was 2. We don't know if it was 6. We don't know if there was other information that could have been contextualized in that or not. That's the purpose of De Giambattista, is to warn the jury, just a caution instruction. This is not counseled as or put in alongside a humane practice instruction that tells them essentially, really puts the thumb on the scale there to say, you got to be very, very careful with this evidence. Here, it's just telling them to proceed with caution, and where the Commonwealth strenuously provides evidence and strenuously provides argument, contextualizing that, I think the jury understands what it is to be, what's to be done there.
How's the jury to understand that when you get all that evidence and then you get this instruction and nothing is said about the fact that you know, somebody might choose to refuse? I mean, it just seems to me there's going to be a disconnect there.
Well, I think the disconnect is closed by the fact that the Commonwealth argues, argues specifically and tells them that, he didn't want to be recorded. He wanted to talk to them without it. I would suggest to you it's because he figured he might have changed some stuff as he's going along, and that's exactly what he did. I don't think the jury is left to be confused at all, because the Commonwealth because DiGiambattista Court gave the Commonwealth the opportunity to make this argument,
like
and they
Bowden,
indeed did
then.
make this argument.
You're arguing it's like no different from Bowden. You can argue it. You don't have to have a judge say it.
Correct.
Okay, but am I correct that the DiGiambattista instruction also says that the jury is entitled to find the statement involuntary solely because it was not recorded?
Yes. And
Isn't that sort of a funny instruction when the person specifically asked for it not to be recorded?
it sort of, I suppose it sort of is, but here I would suggest that, especially in the circumstances of this particular case, and looking at, what happened, that Mr. Dreslinski stops at a part of the interrogation and that nothing further is recorded, I don't think the jury is left with any real open questions here. And as I noted in response to Justice Lang's question and Justice Botsford's question, there is the secondary issue of the particularity of this instruction. And this is not counseled by any other courts that we've seen so far. This is the judge just trying to address these circumstances that I say were presumed to be understood under DiGiambattista. And here, this wasn't objected to error. This was an error that we then have to now look to determine whether the error did not influence the jury or had only slight or minor effect. I would suggest in the circumstances of this case, we have a lot of evidence of GPS data. We have a lot of evidence of where this truck is going at various times. We have Trooper Privero's own statements that are really Trooper Privero's recitation of what Mr. Dreslinski allegedly told her in the course of an interrogation. Those words, as this court notes in DiGiambattista, are the real critical evidence in the case, the defendant's own words being used against him, and where we have an absence of an actual recording for whatever reasons, as this court noted in DiGiambattista. This is a situation where the jury needs to proceed with caution, and I would suggest that cannot be found that this errant instruction that went beyond that allowed for DiGiambattista in two respects had only minor or slight effect.
Thank you, counsel.
Good morning, Your Honors. Jennifer Sullivan from the Attorney General's Office representing the Commonwealth. In light of the uncontroverted evidence of defendant's refusal to have his post-arrest interrogation recorded, first, at the outset, the defendant cannot claim error here because he was not entitled to an instruction under Commonwealth v. DiGiambattista in the first place.
Well, what? I mean, why not? It says if it hasn't been recorded, the judge, upon request, will give it. So why isn't he entitled to it, whether it's been recorded or not?
Well, Your Honor, I would submit that
I mean, if it hasn't been recorded, whether he agreed or not, that's what I meant to say.
That's true, Your Honor. DiGiambattista does say that the instruction should be given in situations regardless of the reason. But I would submit that the case before the court in DiGiambattista is very different than the case that we have here, and it's very different than really any case that has been before any court of appeals in Massachusetts. In that case, we had an unrecorded custodial interrogation where there was no evidence offered either way as to whether or not the defendant's refusal to record was uncontroverted, which again is very different from this case. I would submit here that when you consider the reasons why DiGiambattista came about as it did, it came about because the court was concerned, as it should be, about situations where law enforcement would be able to, in other words, game the system to use strategy measures to...
Well, that wasn't the only concern. I mean, that certainly was a concern in that case, one of a number of concerns. But the other is that this is the best way to get a full and accurate recitation of what can be critical evidence in a case. This is it.
That's true, Your Honor. Referring to a comment that Justice Gantz made earlier, part of the instruction that the court expects to be given as part of D. Giambattista is a commentary on the voluntariness of whether or not the defendant had chosen to refuse the post-arrest interrogation recording or not. And it does seem a bit odd to give an instruction in a case like the case before this court that effectively calls into question the defendant's refusal in this case when there is uncontroverted evidence that was not objected to at trial, that was not examined on cross-examination, that was not commented upon during closing argument.
Let's say that you have a case where in this case, I take it the defendant's decision not to be recorded was recorded.
Correct.
So it was, and he signed something as well. So you've got this uncontroverted case on tape. Let's assume you don't have that. Let's assume there's not a tape recording and the defendant, the suspect, refuses to be tape recorded and also refuses to sign something. All right, so that's the scenario going in. First of all, do you think that the Commonwealth can present evidence that the reason they didn't tape record it is because the defendant refused?
I think the Commonwealth can present whatever evidence it has available to it, whether it be testimony by the...
What should the judge instruct?
In that case, I would submit, Your Honor, that the D. Giambattista instruction would be appropriate, because in that instance, it's quite likely that the evidence of the defendant's refusal to have the interrogation recorded would be disputed. And when you're considering testimony, for example, from police officers who conducted the interrogation, there's an underlying credibility determination that the jury would be expected to conduct in evaluating that evidence. I would submit that that determination isn't quite the same thing when you're facing an audio recording with the defendant's voice stating that he does not want a recording made
When you say
and his
disputed,
signature.
what do you mean? You mean does counsel have to specifically challenge the officer's testimony that, well, he said he didn't want it recorded? In other words, if the officer's cross-examined on issue, then it's disputed?
I think that this is a very narrow exception, respectfully, Your Honor, and I think that because we're focusing on a situation where it was uncontroverted, I mean, that to me is the key in this case, is that there wasn't there wasn't solely testimonial evidence of the defendant's refusal. There was an audio tape, there was a signed form indicating his refusal to have his interrogation recorded. And because the defendant, because defense counsel made no attempt at trial to even challenge that evidence whatsoever.
Can I just ask you about the contours of that? Because there are a number of cases where it appears to be presented to somebody who's about to be questioned that, well, you know, you don't have to have this done, you want to just sign here. So it's an emphasis. It looks like the same piece of paper. So they refused, maybe. They signed a paper that says, I don't want to be, but it's the way it's presented. So does it matter if you just have a piece of paper that says, I don't want to be recorded? Doesn't it bring into question the way it was given?
I see Your Honor's point, and I would submit that it would have been probably, in this case, it would have been likely that defense counsel would have perhaps raised some questions on cross-examination about how that signature was obtained, if that was an issue in this case.
I'm not saying that necessarily it was in this case, but is there some rule? I mean, the rule now is what it is, right? You can provide it in the evidence, there it is. But in general, the point of the rule is to make sure, gee, let's record these. Let's not undermine the effort to have it recorded. Let's not suggest to defendants maybe they don't want to have it. Let's not have a prima facie discussion before the real thing is recorded, as was done in Woodbine. Let's have these things recorded unless it's really, you know, unless there's a refusal, which is different. And then let the evidence speak about that refusal and the prosecutor comment.
Yes, Your Honor. It just seems disingenuous in a case like this where the evidence has not been challenged in any way to allow the defendant to get the benefit of a D. Giambattista instruction, which does cast doubt on the state of the evidence that was presented in trial, because of this underlying, you know, concern in large part of law enforcement, you know, affecting how that refusal was obtained. And because I just think that there is a very big difference between the evidence that was presented in this case and the evidence that was presented in, say, the Tavares case or the Robinson case that was cited. And just to be clear, even if this court does consider that D. Giambattista should be applied in all circumstances, despite the type of evidence that the Commonwealth can offer as proof of the defendant's refusal, the line of cases that have been decided by the appeals court still determine that the additional instruction that was given by the judge after the DJ Batista instruction is perfectly acceptable in these cases because it's simply inviting the jury to consider evidence that's already properly before them in analyzing the evidence at trial. So defendant's contention that there was a problem with the additional instruction is not correct in light of the fact that Robinson and other cases where there is disputed evidence of the refusal, that instruction is still okay in such circumstances.
Thank you, counsel.
Thank you, Your Honor.